creation of way leaves, easements, and public right of ways means the restoration of the value of the land, including improvements thereon, as at the date of the notice of intention to acquire the land. And this is also one of the areas that we have we have had to pronounce ourselves on as a tribunal, because you find that a parcel of land was acquired probably 6 years ago, and we find that could you kindly mute yourself? I think there's someone.
Colleagues, please, let's mute and give the speaker time to present kindly.
Thank you. So you find that there are situations where land can be taken, but 6-7 years later, an award was never issued. So then it becomes what value of the land should be compensated at that time? Is it the value of the land as at the time when a claim has been made before the tribunal, or is it the value of the land as at the time when a notice of intention to acquire was issued? So the significance, as I stated, of the significance of the Land Value Amendment Act of 2019 and these amendments really must be seen in the context of Article 40, Sub-Article 3 of the Constitution, which is in regard to the protection against deprivation of property, unless certain conditions are met. That it is for a public purpose, and that is under 3B. The exercise of eminent domain by the government, and under one thereof that there must be prompt payment in full or just compensation. Moving on then to the tribunal itself. The tribunal then is brought in through this section 133 capital A of the Land Act, which then became section 133A. And it states that the tribunal shall consist of 3 persons to be chaired by a chairperson nominated by the Judicial Service Commission and appointed by the Cabinet Secretary in charge of lands, and members who are nominated by the AG and the Cabinet Secretary for lands. Importantly, the only specific qualification for in regard to the tribunal is that of a chairperson, who's required to be a person qualified to be appointed as a judge of the High Court or a court of equal status. So that means that then the members who are appointed alongside the chairperson can be from different professions, and this is significant because some of the questions that come before the tribunal are of a technical nature, where you need the input of surveyors, valuers, etc. So it's important that when the tribunal is constituted, there's also consideration of other professions which can enrich the jurisprudence of the tribunal. As at the moment, we are only 2 members who are appointed. We've been in office for a year. We're still waiting for a 3rd member to be appointed. But we also have room, pursuant to our establishing law, to co-opt expertise. So whenever we need a question resolved, whether it's in regard to evaluation or a survey, then we have that room to co-opt someone who can assist in that regard. The chairperson is required to serve for 4 years and members to serve for 3 years renewable. The Act does not provide for quorum. And this is something interesting about establishment of tribunals in Kenya. You find that because tribunals are established under different laws, one tribunal can be established and its membership is appointed by either the minister or the Judicial Service Commission. There is provision of quorum, but there is no provision of quorum in other tribunals. But this is an aspect which I think is still being considered through the tribunals bill, which is under discussion to try to harmonize the terms and the manner of appointment of tribunals. In regard to jurisdiction then, our primary jurisdiction is in respect to appeals from the decision of the National Land Commission on matters of compulsory acquisition. This is pursuant to Section 133, capital C1. We also have jurisdiction under 133(6), which is jurisdiction in regard to disputes on creation of way leaves, easements, and public right of way. So previously, this jurisdiction, and as well as the jurisdiction on questions arising from compulsory acquisition of land, were before the Environment and Land Court. But after the amendments came into place, then all these aspects were brought to the tribunal. Remember that before the Environment and Land Court started exercising jurisdiction in regard to this aspect, there used to be the Land Acquisition Appeals Tribunal, I think, which was then, the act was repealed by the coming into place of the Land Act in 2012. So after the repeal of that act, then the ELC was essentially addressing all questions that were arising out of compulsory acquisition of land, creation of way leaves, easements, as well as public right of way. Another important aspect of our jurisdiction is under 133(c)(8) of the Land Act, and that is the powers to uphold and enforce the Bill of Rights and review any administrative actions as to compulsory acquisition. And we will come into more detail in regard to this in a bit. In regard to questions, in regard to appeals from the decision of the National Land Commission, the law provides that anyone who's dissatisfied, and it's important because whenever there is a compulsory acquisition of land and there is an award being issued by the National Land Commission, in the form that issues the award, a project affected person is required to state whether they accept or they do not accept the award. So if you do not accept the decision of the National Land Commission, then you are required to appeal within 30 days of that decision. However, the tribunal may extend time for filing if sufficient cause is shown. So the appeal can either be on dissatisfaction with the procedure that was followed, or on the quantum of what the award that has been issued by the National Land Commission, or both. So in regard to what the tribunal then can do, Section 133(c)(7) gives the power to the tribunal to confirm, vary, or quash the decision of the National Land Commission once an appeal has been filed. In regard to complaints under Section 133(c)(8), remember that when it comes to appeals, the timelines are very strict, that the appeal must be filed within 30 days unless leave has been granted, then to file out of time. But when it comes to complaints under Section 133(c)(8), these are complaints, that come out of the tribunal's powers that originate from, Article 23(2) of the Constitution, which gives Parliament the power to enact legislation in appropriate cases to give original jurisdiction to subordinate courts, and in this case, including tribunals, to hear and determine applications for redress as to violation or a right or fundamental freedom in the Bill of Rights. This is also under Article 47(3)(a), which obligates Parliament to enact legislation to provide for review of administrative action by an independent and impartial tribunal. So when you look at this section, then essentially this is the section, although the primary jurisdiction of the tribunal lies in hearing and determining appeals, you will find that most of the cases before the tribunal will arise under Section 133(c)(8), because they will not essentially be questions of dissatisfaction with an award issued. There will be questions of, my land has been taken, but there is no award. My land has been taken, I was given an award 5 years ago, I've not been paid. So where do you go? Or my land has been taken, I was given an award, I accepted the award, but the land that has been taken on the ground is much more than what was gazetted. So how do you then, how do you find a relief, or where do you go when such a case happens? Because there have been situations, and this is actually contemplated in the law, where the law states that until and after the National Land Commission has done the final survey, and it sized the acquired land from your title, and issued new titles for the government entity, that is the time you will, that is the close, that is the end of the process of compulsory acquisition. So it's possible that if the initial intention was to acquire 2 acres for building of a government infrastructure, and the infrastructure ends up taking 3 acres of the land, that the person who is affected by that acquisition is entitled to be compensated for the extra acquisition, for the extra land that has been taken. But you'll find that in many cases, there will be a back and forth between the commission and the project affected person. The person will write letters to the commission, to the government entity that acquired, that the commission acquired on behalf, and there will be, a back and forth, no clear direction on what exactly happened or how much land was taken, because the process of compulsory acquisition starts by a request from the cabinet secretary in charge of that particular entity. If it's Kenha, for instance, for building of a road, the cabinet secretary for roads will write a request to the National Land Commission that these are the acquisition plans we wish to acquire so much land for building of a road. The National Land Commission will scrutinize, it will say okay, and it will gazette the acquisition. After the acquisition has been done, then they will send a schedule of payments to the entity that is acquiring. The entity will be told, pay 2 billion for this number of project affected persons. The money is sent to the National Land Commission, and the National Land Commission goes ahead to disperse the money. But then 2-3 years down the line, a project affected person comes and says, my land was acquired, I was paid, but the project has taken the whole parcel of land despite just gazetting a piece of it. So then the difficulty that arises out of this is that the money that was already, put aside for this project was this much. So there will be questions of whether, should there be more money allocated for the same. The National Land Commission will say, okay, we don't have any more money for that. So then any party that is affected by such a situation has the right to approach the tribunal under section 133C, subsection 8. And the tribunal can order that a survey be done. The party can file its own survey report. The parties can file a joint survey report, as well as a visitation to the property to actually conduct a survey before a decision is made. So this is one of the avenues that really presents the biggest opportunities for complaints, so-called, that are not covered by an appeal process as such, because people might not be dissatisfied with the amount they've been given, but they are dissatisfied with certain aspects of the compulsory acquisition that then affect their rights to ownership of the property, of the land. So then under section 133C, section 8, the Fair Administrative Action Act at section 11 lists the various orders that may be granted, including declaratory orders, restraining and prohibitory orders, compelling orders, temporary reliefs, costs, etc. It's, I think, a wide array of options that the tribunal has in regard to grievances. So on the question of timelines, a person aggrieved, as I've stated, may only appeal within 30 days, and if they fail to do so, they can always apply to the tribunal to extend the time if sufficient cause is shown. And the tribunal is required to make a decision within 60 days. It's a very ambitious timeline, but I can tell you, and when I'll give the statistics of the tribunal, that in most of the cases that have come before the tribunal, we have actually given decisions within 60 days from the time the case was filed until the final determination. This, I think, is a serious departure from the norm of doing things, and is one of the reasons why more people should embrace tribunals in terms of seeking justice for their clients, because their timelines are quite strict and they tend to deliver within a short timeline as compared to the ordinary courts. The tribunal is also required to develop its own rules. We are in the process of developing these rules, and we will be, of course, engaging with our various stakeholders before the same can be issued officially. In the meantime, what we have been doing at the tribunal is that we issue directions in terms of filing responses, in terms of filing responses and also hearing the matter, so that then we're able to complete the process within a reasonable timeline. Appeals from the tribunal lie to the Environment and Land Court, and this can be on the basis that the decision of the tribunal was contrary to law, substantial error or defect in the procedure adopted, the tribunal failed to determine some material issue of law, and essentially these appeals may only be made on a question of law only. So the format for filing is, as I've stated, we're in the process of developing our rules. So far, there are no rules in terms of what kind of pleading you can file. A number of people have approached the tribunal by filing claims, memorandums, claims, complaints, etc. And these are all accepted, because really, essentially, the bottom line is that a clear identification of the grievance and the reliefs being sought must be done in whichever format that you choose. However, looking at really what the law provides, our suggestions in terms of what the practitioners should adopt, and this will be reflected in the rules, is that appeals should be done through a memorandum of appeal from the National Land Commission, from decisions of the National Land Commission, and then in the cases of compulsory acquisition of land, and also in cases of way leaves, creation of way leaves, and public right of way. There are also other areas where the tribunal can exercise its jurisdiction, and this is in the area of easement, where you need just an entry order or an access order in order to pass your construction material on someone's land without necessarily acquiring any interest in the land. So this then can be done through just simple forms of applications. And a complaint under section 133C8 can be in the form of a complaint or a petition, because really it seeks enforcement of rights. So when it comes to how far we've come and what kind of caseload that we have seen a total of 81 cases which have been filed in the past 1 year since we came into office. A number of these have also been transferred from the ELC, where cases had originally been filed before the Environment and Land Court, before the tribunal came into existence, and then the same are transferred to us. But our experience so far has shown that the more people get to know about this tribunal, the more the practitioners get to know about this tribunal, the more they are embracing it. As you can see, out of the 81 cases, 9 have been filed this month. I was just looking at the statistics and realized that 9 cases were filed in a period of 2 weeks. So you can see that the frequency of filing cases before the tribunal is going high. We're having some months where 10 to 15 cases are being filed, and probably in the next year our statistics might go higher than this. The good news, however, is that cases that have been determined so far are 44 out of the 81 that we have. And the turnaround time has been between 60 to at most 90 days. So that is from the time a case is filed until a final determination through judgment has been done. So I want to come to this section so that then we can enable ourselves to have some conversation around what is exactly the tribunal doing in terms of its creating its own jurisprudence or the matters that come before it. So the first question, of course, when a new tribunal comes into place, one of the first questions we faced in I think this was in our second or third matter, was a challenge to jurisdiction. So then you find that some parties are of course hesitant to know the extent of jurisdiction of a particular court or tribunal. So, and in this particular case, it's a question whether the tribunal had jurisdiction to determine whether the land that had been taken was more than what was originally gazetted. And in this case, then our determination was that the language used in the Land Act, it refers to a matter relating to, and a matter relating to then is any matter that is connected with the process of compulsory acquisition. So we found that our jurisdiction then starts from the point when an intention to acquire property is shown up to until compensation and the property has been handed over to the government entity. So in this process, it's a long process, and one of the early decisions in regard to compulsory acquisition under the new dispensation, the Patrick Msimba case, has detailed the process of compulsory acquisition, especially under Article 107 of the Land Act, from the beginning to the end. So in between, there are lots of issues in regard to identification of, whether the correct acreage was acquired, the correct amount was paid, issues to do with who got paid, who didn't get paid. Persons who might have other interests over the property other than, ownership. And we'll come to look at that question of, occupiers in good faith. So this whole process has many aspects to it. And along the way, there could be a number of, legal issues arising. And that's why we determined that, indeed, the Land Act bestows jurisdiction upon the tribunal to determine all these questions. There has also been a challenge in regard to whether the tribunal can adjudicate over questions that touch on rights to property ownership. And this was raised in the case of Ngoje and 6 others, was the National Irrigation Authority and another, where we determined that indeed Parliament envisioned and acted in accordance with its powers under Article 23 to confer jurisdiction upon the tribunal to adjudicate over matters for redress of a denial, violation, or infringement of a right. And then in this particular decision, we actually went at length to trace where our jurisdiction comes from, especially Article 133C8, which is broad enough to include jurisdiction in regard to redress of a violation of a right. So we found that this flows from the powers given to the legislature under Article 23, 2 of the Constitution, to enact any legislation to give this kind of jurisdiction to a subordinate court. And in this case, the tribunal is also a subordinate court to redress, to determine applications for redress of a denial, violation, or infringement of any right. So this was our determination, but the same is on appeal. And of course, we look forward to hear what the Environment and Land Court says in regard to this question, so that then it can enhance our jurisprudence as well. One of the most controversial questions that has come before us in regard to jurisdiction is a question whether, we have jurisdiction to hear disputes concerning creation of way leaves under the Energy Act. For those who have practiced before the Energy and Petroleum Tribunal, you know that previously there have been all these cases, where somebody's where a way leave has been created on someone's land and they're dissatisfied with the compensation. Then they go to EPRA, that is the Energy Petroleum Regulatory Authority, and then the EPRA's decision is appealable to the Energy and Petroleum Tribunal. I know there is the case of the Court of Appeal decision in Abida Nicholas, which talks about the doctrine of exhaustion. And that particular case actually says that questions in regard to creation of way leaves should be determined by the Energy and Petroleum Regulatory Authority. So on the basis of this decision, parties have come to us waiving the decision and saying, hey, stop in your tracks because you do not have jurisdiction. But then parties that have filed matters before us have come on the basis that actually Section 133C6 specifically mentions jurisdiction to determine disputes arising from the creation of way leaves on the Land Acquisition Tribunal. So we've had about, I think, 5 cases where this challenge has been mounted. And our earliest decision, I think, which came out in January this year, in the Matthew Karagania case versus Ketraco, we stated that in our opinion, the creation of way leaves relates to acquisition of interest in land, and hence by dint of the subject matter, such disputes can only be properly adjudicated before the Land Acquisition Tribunal. So, and we were clear that, for us, it was very clear, this intention of the legislature was very clearly expressed in the Land Act. But we also went further to look at, to compare the two institutions, the Land Acquisition Tribunal vis-a-vis EPRA, and we came to the conclusion that, in our view, the right forum to adjudicate such questions would be the Land Acquisition Tribunal. I don't want to say much about this because the case is currently on appeal before the Environment and Land Court, and hopefully we can get to have this clarity made, because in our view, we've also expressed this in another matter. It's possible that there is overlapping or analogous jurisdiction between EPRA and the Land Acquisition Tribunal in regard to creation of way leaves. But when you look at the Land Acquisition Tribunal, if a matter comes to us, there's nothing that tells us that we should give, we should decline exercise of jurisdiction. And it's possible that this is a legislative drafting error, and hopefully once clarification has been done by the ELC, then the legislature can take it up to clear the air in terms of which body exercises jurisdiction. This is not a unique case, overlapping jurisdiction, I think, in terms of our laws. But for now, this is really a question that has caused a lot of objections from entities in the energy sector, especially Ketraco and Kenya Power and Lighting Company. Another question that then we have also determined is the question of what amounts to just compensation. When we look at what the law says, and this is what I started with at the beginning, the Land Value Amendment Act of 2019, it provides that Parliament or the Ministry of Lands was going to come up with a criteria through the Land Value Index, which would enable then, for compensation to be made pursuant to a determinate criteria under the law. But we found that in certain cases, the National Land Commission relies on values which are not anchored in the law. In this particular case, the National Land Commission was relying on certain values that had been supplied by the Ministry of Lands. Remember that there's no criteria, there's no land value index that has been developed. And the law is very clear that to develop this land value index, you must have the input of both houses of parliament. The Senate as well as the National Assembly must give input. But then you have, values which are contained in, certain documents. To say, for instance, that the area of Naivasha, land should cost between $1 million to $1.5 million per certain, size of land. So you find the National Land Commission picking such estimations and applying them in issuing awards. And in this case, we found that that was not in adherence with the law, and the proper determination of values for compensation must determine the market value of the land as at the time of acquisition. And without a land value index, which is contemplated under Section 107A, the respondent, who is the National Land Commission, is then under a duty to obtain ascertainable recent comparables. And this, for the valuers, they do understand that this then goes into coming up with a value through a valuation process which has methodological transparency. That then when it comes to the tribunal, you are able to show how you arrived at a particular figure for compensation of land. Yeah. Another question that we have had to determine, as in almost all the cases that we have, and really this is the point of the exercise of eminent domain, you never find people challenging the exercise of eminent domain itself. Mm. You cannot challenge the power of government, to acquire property. I think that is the thinking. But then there is one case that challenged the whole process from the beginning and whether indeed the compulsory acquisition was warranted. And in this particular case, we made a finding that the National Land Commission is not a mere conveyor belt in acquisitions, and was under a legal obligation to ensure that the acquiring authority has complied with the Constitution and the law before an acquisition is commenced. Remember, Article 40, Article 3 of the Constitution requires that acquisition must be for a public purpose or in the public interest. So that is the first criterion. So as a minimum, it has to be shown that this acquisition was for a public purpose. And after that, then you have to move on to the other stage to look at whether this particular acquisition is necessary, the necessity of the particular project in this particular area. For instance, you cannot, just out of nowhere, state that, you would like to displace a whole village because you feel like you should build a university in this particular village. So for us then, reading the law and the Constitution, we find that there is a requirement in the Constitution and the law that the acquiring entity shows that any possible alternatives have been considered, and this is the best alternative for purposes of acquisition. Evidence of availability of funds, and we explain further in this particular case to say that acquisitions have a very disruptive effect on the persons that have been affected. So if you're going to acquire land and existence of funds is merely speculative, on the basis that, there will be money to compensate people, then you cannot, start the process without there is clear evidence, at least, budgetary provisions for purposes of this particular project. Furthermore, it was our finding that an acquisition should not merely happen without, really the National Land Commission being satisfied that the proposed use of this land, complies with the existing use and the future, plans that might be in this particular locality. So this really is the importance of the process before the notice of intention to acquire, because the request comes from the ministry concerned, goes to the National Land Commission. The National Land Commission needs to now engage actively and even engage with the communities affected before a decision can be made at this stage, and also later on when it comes to compensation. So all these are matters that the National Land Commission then should come up with, and the law requires that they have to come up with a criteria that must be complied with. But we found that they had not come up with a criteria, and in this particular case, the acquisition was actually not warranted. And this is the case of Thuo and 151 others versus the National Land Commission and 5 others. The fourth issue that we have decided is in regard to, the failure to pay compensation within a year. We found that a failure to provide an explanation or a justifiable explanation why compliance has not compliance with Article 40 sub-Article 3 of the Constitution has not been done, then amounts to a violation of the complainant's rights under that article. This, we stated that is premised on the reasons that compulsory acquisition really causes a very disruptive effect on the affected persons, and hence government should ensure that there is timely compensation, but not exceeding 1 year after compensation of the acquisition has been done. Fifth question, and I think this really might be of interest to practitioners in the coastal region, is the question of occupation in good faith. The law requires that occupiers in good faith are required to be compensated. This essentially means that, could you kindly mute? I think there's someone who's unmuted. Just so you find that there are occupiers on a property who do not own the property, they do not have title to the property, but they are occupiers in good faith, tenants, persons who are carrying out any other business on the property with of course, the consent of the owner. I think this.
Kansongaira, could you kindly mute your microphone? Thank you. Back to you, Nabe.
Okay, thank you. Thank you for that. So you'll find that Section 107A10 strictly states that an occupant in good faith does not include a person unlawfully occupying any land without the consent of the owner. I know this is a controversial issue, and we're yet to deal with one of these issues, but we do anticipate that such issues will come before the tribunal. You have families who have stayed on parcels of land for years.
Hey, I'm looking for the issue of deposit.
For years, and they've done so without the consent of the owner, or they are the so-called squatters. But that is a question that will come, and it will be dealt with at the time when it comes. However, of particular interest as well, for practitioners who have, clients from the corridor where the standard gauge railway was developed, especially along, I think, Kwale, where there are those where there are group ranches, but the owners have not, do not have titles for specific parcels that were acquired. Then this section is relevant to you. If you look at Section 107A12, it states that where boundaries of land are ascertainable, prompt payment in full of just compensation may be made to occupants in good faith in the case of land lawfully held, managed, or used by individuals or families as ancestral land, and 2, land traditionally occupied by individuals, families, or entities pending adjudication. And for land practitioners in this aspect, they'll tell you that there are many issues around adjudication of land. At the point when a compulsory acquisition happens, the National Land Commission does not come to the ground and say there must be adjudication before we take this land. They proceed, acquire the land, engage with the persons on the ground to try establish ownership. Because at the beginning, it's a requirement that the National Land Commission must identify the owners of specific parcels of land. So when it comes to unadjudicated land and surveyed and registered land, then it boils down to who do they find on the ground? What tools are there, especially with local administration, to establish the owners of the specific parcels of land? And then what does the law say? The law expects that this compensation will be given to persons who have been identified as the owners, and it will be paid. But then we have cases that have come before the tribunal where the National Land Commission, many years down the line, tells them, we will not pay you unless you produce a certificate of title. So in the Gunda case, Gunda suing as a legal representative of the estate of Banzi, Gunda Banzi versus Kenya Railways Corporation and another, we stated as follows: the Constitution and indeed the Land Act does not discriminate based on the different land tenures when it comes to the rights under Article 40 sub Article 3. In fact, Section 5 of the Land Act expressly states that there shall be equal recognition and enforcement of land rights arising under all tenure systems and non-discrimination in ownership of and access to land under all tenure systems. This provision unequivocally requires the respect of land rights arising out of dealings in regard to land under all tenure systems recognized in the law, which include customary land tenure system, which would ordinarily entail unsurveyed and unregistered land. It is incumbent upon the second defendant to come up with the structures that recognize a differentiated approach to proving ownership for unsurveyed and unregistered land. So it's not a straightforward situation, I know, and most times the National Land Commission will act out of abundance of caution that they will not issue compensation without really verifying who the owner is. But at the point when the issue of ownership was verified on the ground and they got to verify who the owner was, they cannot come later and disregard that documented establishment of who the owner was and tell the persons whose land they acquired 5 years ago to produce ownership documents. I think this is one of those areas that the National Land Commission probably should do more to establish this. Just one last slide or two before we open this floor. In our view, we found that the National Land Commission, absent any challenges, because we all know how emotive land is, especially on ownership. Unless there is any dispute on ownership, which then entitles the National Land Commission to withhold the funds lease pendants while the dispute is pending. If there is no dispute on ownership, once verification has been done on who the owners were, who on the ground, by the traditional methods or any other well followed process of establishing the ownership, they were bound to pay the owners. In our view, sending back villagers and telling them they must come with certificates is an elitist approach to how we view land tenure systems in Kenya, because as much as there are laws in terms of adjudication of land, registration of land, we must be cognizant of the fact that not all land is registered, although there are processes of towards registration. The same have not all they have not applied uniformly throughout the country. And lastly, there's always the difficulties which the National Land Commission must recognize in dealing with these group ranches. For instance, it would be easier to say, okay, let's give money to the group ranch, but then that will the persons themselves will tell you that, what, for us, identify the person, as long as it's clearly demarcated that this person belongs to me, pay me directly, rather than putting that money in a group ranch, which will end up not being paid to the correct owners. I think I've said enough for now. Let me stop there and invite questions for discussion. Thank you.
Thank you very much, Council, for that very elaborate discourse. I believe it was quite elaborate and extensive, and you managed to ask and answer most of the questions that we would have had in mind. I say this because I do not see any questions posted on the chat. However, as we promised, we will be giving an opportunity to members to also answer questions, ask questions live. So if you do have a question, kindly raise your hand so that may recognize you. And as the members are preparing to ask those questions, I think I just want to say once again, thank you for the presentation. It was very well written and very, very well delivered. And I think it was very easy to understand, and it shows why you are a teacher. The teacher in you has made it very easy for us to understand. I see the questions are now beginning to trickle in, and this is likely the question that I would also have wanted to start with. Thankfully, Oliver Manyasi has asked this question, so I would want to ask on his behalf, unless he would like to ask himself. But he wonders what challenges, obstacles, or hurdles you have encountered that you would want the members of this bar who practice before you to possibly address or be alive to. So that's the only question that I have seen so far.
I can take
Maybe
that as
that.
we figure out if there are
Yes.
any other. Thanks, Oliver, and good to see you here. Are there any hurdles that we have encountered, and how can the members of the bar assist us? To be honest, coming in and chairing a tribunal with no prior experience sitting from this other side has, first of all, been a very humbling experience for me, because I've come face to face with a situation where then you are managing a process to ensure that at least litigants have timely justice. And I think one of the challenges that we have had to deal with are to really explain to our customers and litigants that, listen, here we do not have endless time to give you, to comply, to file your responses. We are time bound by submissions. I mean by the statute, in terms of us having to put our case in order and to proceed forward. And I must say, we have had a wonderful, cooperation from the bar, that over time now our practice has been simplified. We all know our expectations, and I'm glad that sometimes, I mean, of course, we have to be a bit strict in terms of what we demand from the members in terms of what they are supposed to do. But we're happy to report that there's been very positive feedback, and we have been amazed by how much the bar has embraced tribunals and our procedures. We've also done something I did not mention. We've done circuits. We go around. We've gone around the country whenever we need to visit a site. There are times that you have to actually see, what is being alleged in the papers, and this is the good thing about tribunals. We have that in us to visit and actually to verify, and we've gone around the country, and what we can ask of the membership is, as much as possible, ask your clients to consider the various avenues and different tribunals that are there when they have any issues to file. I also didn't say this, that filing is done online through the CTS. All our filings are done online. All our sittings are virtual. However, if a party requests and it becomes necessary, we can hold physical court, and we've done this. We can either hold the physical court in Nairobi, or we can hold the physical court where the issue has arisen. We've done this in Kisumu, we've done this in Malindi, and we've done this in Thika as well. So parties, depending on what really is important for that particular case, and we say this because of also the concept of access to justice. Sometimes we've had a case where you have more than 200 litigants of old age, from a place where there's no easy access, to this kind of facilities that we have. We found that it's necessary sometimes to make an exception to the virtual sittings to actually take the court to the people. We have visited affected lands in Nyatike, so that then we are able to hear from the litigants themselves and to see for ourselves. So I think what we can ask the members is to just be good ambassadors to what we do and enable us to keep doing it.
Thank you, Daktari, for that response. I think it's very timely, as you say, that, well, what we wanted, would have wanted to see also is the practical aspects of how filing is done, which you have described on the CTS. You've also mentioned that you do have physical sittings at times. Probably you could consider having a circuit, because as you know, land is quite an emotive subject. And as you mentioned, there are instances where the parties are of old age or vulnerable groups or just a large number. And we would wish to see justice to appear to be done as much as it is also being done. So it really makes a difference when the parties are able to attend court and have their day to be heard. So we do look forward to hosting you in Mombasa very soon. And I have another question coming in from the convener, Ms. Council Oluga. You had a question, please proceed.
Thank you so much, Eva. I want to take this opportunity to thank Daktari, who is my good friend and classmate, for that very illuminating session. I have a number of questions. I don't know whether time will allow. Some are from myself and some I've received from others. First of all, the practical aspects. You have told us that the filing is done online. Is there any filing fee? And after I have filed, do I sit and wait for the tribunal to invite me for a hearing? Do I serve the other side, or do I walk to the tribunal and fix a date for hearing? That is number one on the practical aspects. Number two, you mentioned something which is very interesting, that the tribunal is currently comprised or composed of 2 members. If you look at section 133, cap A, subsection 2, it says that the tribunal shall, and you remember this word shall, people always take it to mean it is compulsory. It shall comprise of 3 members. Now, is the tribunal properly constituted, or are we going to see challenges where somebody will move to court after the tribunal has made a decision and say, look, the tribunal was not properly constituted? And in relation to that also, what happens where there is a tie? Sorry, somebody is interfering. I request that we mute. What happens where there is a tie between the 2 members? Who breaks the tie, or what should happen in such a case? Number 3, there is something interesting here that you mentioned, where you are saying you are talking of how compensation, how NLC actually is supposed to ascertain, come up with a value, ascertaining the recent comparables of lands in the vicinity. Now, my question is, if the tribunal, the NLC rather, comes up with a figure and says Oluga is entitled to compensation of so much, can I come to the tribunal and say the money that NLC has given me is little and ask for a specific amount, and can the tribunal grant me? In essence, can the tribunal alter the figures of NLC and supplant that with what the tribunal in its view thinks is reasonable compensation? Number 4, I said I have many questions. You mentioned on jurisdiction that the tribunal can deal with any matters related to the process of compulsory acquisition. What I have in mind is where 2 peoples are rivaling. NLC has given person A an award. Person B is saying, no, I am the owner of this land. So there's a dispute on ownership. Can the person who thinks that award has been given to a person who is not the owner of the land come to the tribunal and say, I'm the owner of the land and therefore I am entitled to the compensation? And that will mean that then the tribunal will have to make a determination on ownership of land. Does the tribunal have such jurisdiction? Another question is, does the tribunal have jurisdiction to grant interlocutory remedies if there is an urgent situation and I need urgent redress? For instance, I have dealt with cases where NLC wants to take possession, or the acquiring entity wants to take possession of the land, and the law, section 120 of the Lands Act, says that in case of an emergency or urgency, they can take possession. Now, they have not given me a word and they want to take possession. Can I come to the tribunal and get an injunction to stop them? Does the tribunal have such capacity? And another one, as I finish, these 60 days within which to determine or to make a decision. From my reading of the Act, it appears it is cast in stone, but you earlier mentioned that the tribunal can extend the time. I don't know where that is provided for. Maybe you can guide us on that. And finally, have you dealt with a situation where NLC is the one that is moving the tribunal rather than private persons? Thank you. Thank you so much.
Thank you. Thank you very much, Councillor Luga. I think the questions warrant me to retreat and write judgment on them, but I will attempt to address them right here. Filing fees. The filing fees is as per the directions of there's a memo from the Chief Justice. It's similar to what the other courts, especially the magistrates courts, charge. Most of the fees, if it's non-liquidated, it's 1,000 shillings. But if it's liquidated, then it can go all the way to 70,000, depending on value. What happens after filing? So what we have done, we have just adopted some practices pending our rules. So as soon as a matter is filed, if you file a matter today, the tribunal will give you directions today. So we have adopted the model of the small claims court, which immediately give directions on the filing of responses, and I mentioned it upon filing of a matter. So if your matter is filing today, file today. Before close of business, you will find directions in your email. The composition of the tribunal, it's a question that is actually alive before the tribunal. I wouldn't want to say much about it because we are issuing a ruling on the same on Friday. But there is jurisprudence around the question of composition as well as the question of quorum. And I think there was a case where one of the commissions that was challenged in court on whether a composition as a whole means that all the members must be present for it to be validly composed. It's a question that I will let our ruling on Friday speak to it. I'll be happy to share the same so that then members can see what we've said. In case of a tie between the two members, good practice dictates that the chair will cast a vote, will cast the deciding vote. That is good practice from around the world. When it comes to whether you can, the tribunal can alter the value, indeed we have. And there are cases where we have determined that the National Land Commission, the evaluation did not adhere to the law, And we've sided with the evaluation that has been supplied by a party, where we find that that valuation is shows methodological transparency and is the closest value as compared to the one that was supplied by the National Land Commission. In other instances, we've actually come up with a different figure, which was not what the National Land Commission awarded or what the party is seeking. Looking at both valuations and the comparables that have been applied. There's also an important question that you asked, that there are two rivals. Person A, has been given an award, but person B disputes ownership. Questions about ownership of land are questions that are within the jurisdiction of the Environment and Land Court. However, there is a section of the Land Act, and we find it, where the law allows the National Land Commission, by reference, to come before the tribunal, to file a reference before the tribunal on questions of validity of any document or questions of ownership. So the National Land Commission, if faced by this situation, they are entitled to file a reference before the tribunal to ask the tribunal to determine who should be paid. So if it comes to us from the National Land Commission, then we can determine the same. But a party who is challenging ownership of a parcel of land cannot come to challenge the same before us. That is a question for determination by the National Land Commission. The National Land Commission at the inquiry stage has a duty pending any determination, any question that is before us. 60 days extension of time. I just wanted to read for you. Let me just check if I can open there. The Land Act quickly. It gives us, actually, it's extension of time is more specific in regard to extending the time within which we should determine a mark, rather than even in regard to extending a time for the filing of applications or appeals. Let me just read for you that provision. Yes. So, so as 133C Cap C3 says, within 60 days after the filing of an application under this part, the tribunal shall hear and determine the application. 133 Cap C4 says, despite subsection 3, the tribunal may, for sufficient cause shown, extend the time prescribed for doing any act or taking any proceedings before it upon such terms and conditions, if any, as may appear just and expedient. And really, this has, at the beginning we were pretty ambitious, and we still are, with compliance with the timelines. But then we find that sometimes it's impossible to comply with the 60 days timeline, because we've ordered for a survey report. That survey report has not been produced. We need to do a visitation. We need to do a number of things. A certain party has not brought a very important document before the tribunal. So you find that there are situations where we then have to extend the timelines. within certain periods without necessarily just, taking as much time as possible. But the biggest hurdle to compliance with the 60-day timeline has been the filing of responses from the respondents. We have done all we have within our powers. Sometimes we have to summon officers of the respondents because a month after a filing has been done, there is no response. So we have had to use, our coercive powers to summon persons before the tribunal, sometimes to get things done. But I think we have established some practice, which over time, with the assistance of counsel on both sides, we are managing our caseload. Has there been an instance where NLC has moved the tribunal? No, because most of these matters are really, they're challenging the decision of the National Land Commission. But there are certain situations where the decision being challenged is a decision of the National Land Commission to abandon its earlier decision. Okay, the National Land Commission, for instance, may issue an award today for 2 million shillings. 3 months down the line, they abandon that award, issue another award. So there have been questions touching on whether Fair Administrative Act was complied in terms of revisions of awards that have been issued, and those are questions that we have, of course, dealt with. I think I saw 2 other questions. I'm trying to find where the chat appeared to. I saw the chat. Where is it?
There's in the chat section, Saima and Silas.
Yes, the first question, are there mechanisms the tribunal can use to monitor compliance, ensuring that the land acquired is strictly used for intended purposes, the purpose it was intended for? It's an interesting question, but if, for instance, a land is acquired for building of a public school, but the same is never done, the law requires that the same should be offered first to the person it was acquired from, if they are able to purchase it. But it can also be offered for another public use. So unless someone challenges this before the tribunal, then the tribunal will really not have any way of ensuring that land acquired for a public purpose is applied to the same. What are some of the grounds for enlargement of the filing period beyond the 30 days after issuance of an award? Let's say that an award is issued and a party who got the award did not become aware of the award, and I think this has to be on a case-to-case basis, that if a party comes to you and says, okay, I was given the award, like one of the cases that we have had to extend time, I filed my appeal before the Environment and Land Court, but then my case, the Environment and Land Court said, now the tribunal is in existence, you have to go back there and file the appeal there. They say, okay, it's been a year that I had filed, so then we have this basis to extend. Or, you are unaware of the award that was issued, as long as the time that has lapsed is not unreasonable and the reasons make sense, then the tribunal will enlarge the time. It's essentially the kind of jurisprudence that the courts have developed around enlarging time to file an appeal. If you look at decisions of the High Court as well as the Court of Appeal, and when such enlargement can be done. So it's a question where the tribunal has to exercise its mind and consider whether the reasons advanced do make sense. I think that's the last question I saw on the chat. Unless there's any other.
Thank you. I'm not sure whether I may have dropped off or there was a problem in connection. I didn't get one question whether it was answered on the issue of interlocutory orders. Could you just very briefly whether it was answered?
Yes. I indeed indicated that the tribunal can issue interlocutory orders, and this power, of course, comes from the Fair Administrative Action Act, as well as the tribunal itself, its ability to manage its own affairs and to ensure justice for the parties, then gives it powers to issue interlocutory orders whenever necessary.
Okay. So thank you very much. It has been a very insightful presentation, and I believe most of us are very grateful, and we look forward to coming to practice and bring our matters before this tribunal. We'd like to now invite Council Jackson Mushiri, who is MLS Council member and member of the ELC committee, to give his vote of thanks. And just before that, I'll request Daktari if you have any closing comments, and then Jackson can come on.
Thank you very much for the invitation. It's a great honor, and we do indeed also just to speak on behalf of our Registrar of Tribunals. We have been doing this sensitization around about our tribunals. There are more than 24 tribunals which have transitioned to the judiciary, and there is really a lot more to share in terms of their work. So we are really privileged that you invited us, and we encourage you to also reach out to other tribunals so that they can also talk to their membership. And thanks all for those who came and listened and asked the questions. Thank you.
Thank you. Over to Jackson, Council Mushiri.
Thank you, Eva. Thank you so much. You can hear me?
Yes, we're getting you loud and clear.
Yes, thank you so much. This is Jackson Mushiri. I'm a council member, and my work here is to give a vote of thanks. And definitely I would like to thank the speaker, Dr. Orina. Dr. Orina happens to have been my classmate, for those who don't know. A few years back, looks like he went ahead of me and acquired more papers. I need to catch up. But thank you so much, Daktari, for coming and speaking to our membership. I hope Moi University is still there, where I can see from your CV you're teaching. I hope it's still in existence. The MLS Council. Yes, Daktari, is he still there? Are you still teaching there?
Yes, indeed. Yes, indeed. The hitches will be resolved in due course, I believe.
Okay, thank you. Thank you so much. I'd also like to thank MLS Council, Mombasa Law Society Council, for making this happen. You've given a lot of support for our convener, and we greatly thank you. We also like to thank the ELC committee, the ELC committee led by our able brother, Willis Oluga. You've done a great job. Just the other day we had another engagement, and today we have another one. I think the ELC committee are overworking, and we really thank you. And for our members who are not in any committees, please get into a committee and make sure that you are engaged with the issues to do with the society. The moderators, Eva, Janet, we thank you. Thank you for your time. You know, you had to take your time to prepare for this. It is not easy. Not so many of us can do this. For those who have never moderated, please gather some courage and moderate a meeting. It takes one step and another, and you become as good as our moderators for today. I would also like to thank all of you who attended the session for today. You took your time. We really are truly grateful. You took, I'm sure some of you had to give up some of your assignments, seeing clients, drafting and whatever, and to attend this. So we are very grateful. And last but not least, we thank the Almighty God for giving us this great opportunity to be able to do everything. It all comes back to Him. So thank you so much. Back to the convener and the moderators.
Thank you, Council. Please invite us where you are. We would like to practice next to that beautiful view. So thank you all for attending. This marks the end of the session. You're free to leave at will. And maybe, Daktari, you could just drop us in the chat your contact, if you do not mind, if there are any other questions, or you could direct your questions to the convener or MLS. I say to drop the chat because I recognize that there are some members who have attended from outside of Mombasa. So if there are any other questions outside what has already been tackled today, please do feel free to make contact with the Mombasa Law Society ELC committee, who will channel the questions to Daktari or to the contact that will be placed in the chat. Thank you all, and do have a wonderful week ahead.
Thank you so much.